Hello everyone, this is Crypto BitLaw, back with another blockchain legal brief, and today we're going to discuss how Binance recently won the dismissal of a major class action lawsuit that was filed against it. But before we dive in, please, if you like this content, hit the thumbs up and subscribe to our channel. We'd really appreciate that. And with that said, let's dive right on in. Alright, so here we can see Cointelegraph reports that Binance wins dismissal of class action over 2018 tokens that tanked. The judge ruled domestic law doesn't apply to Binance, as it is not an exchange domestic to the United States, and that the case was filed, quote, too late. A federal judge has dismissed a class action complaint asserting Binance violated United States securities laws by not registering as a broker-dealer or exchange and sold crypto tokens that were not registered with the U.S. Securities and Exchange Commission, the SEC. The original complaint filed in U.S. District Court for the Southern District of New York was brought by a group of investors who say they invested in the tokens EOS, BNT, SNT, QSP, KNC, TRX, FUN, ICX, OMG, LEND, ELF, and CVC around 2017 and 2018. An amended complaint was filed only listing 9 tokens with BNT, SMT, and CVC removed. The investors said the tokens had lost much of their value since purchasing and were seeking compensation for the price paid for the tokens and the fees paid to Binance in connection with their purchases. Quote, Binance and the issuers wrongfully engaged in millions of transactions, including the solicitation, offer, and sale of securities without registering the tokens as securities, and without Binance registering with the SEC as an exchange or broker-dealer. As a result, investors were not informed of the significant risks inherent in these investments, as federal and state securities laws require. The investors further claimed that Binance capitalized on the enthusiasm brought on by cryptocurrencies, marketing tokens and initial coin offerings, ICOs, on behalf of projects and profited off the associated trading fees, adding that investors, quote, purchased the tokens with a reasonable expectation of profit from owning them. In his decision on Thursday, Judge Andrew Carter said that as the investors waited more than a year after purchasing the tokens to file the complaint, they had sued too late. Most of the tokens were purchased in 2018, and the original filing wasn't until April of 2020. The investors argued that the SEC published a framework asserting digital tokens were securities in April 2020. The timeline for complaint submission should have started then. Carter found that the relevant laws apply when the supposed violation occurs, not when it is detected. Judge Carter also said that domestic security laws are not applicable to Binance, as it is not a domestic exchange in the U.S., being headquartered in the Cayman Islands. Binance does use Amazon Web Services to host its infrastructure, and that is based in the U.S., but that isn't enough to consider Binance as a domestic exchange. Quote, plaintiffs must allege more than stating that plaintiffs bought tokens while located in the U.S., and that title passed in whole or in part over servers located in California that host Binance's website, Carter wrote in the motion. This isn't the only class action lawsuit filed against a crypto exchange on such grounds. On March 11th, a suit was filed against Coinbase in the same court, alleging that it's operating as an unregistered securities exchange. Similar arguments are being directed at Coinbase, with plaintiffs saying they were not warned of the risks of cryptocurrency investments. Binance did not immediately respond to Cointelegraph's request for comment. All right, so here we can see a copy of the docket, and if we turn to the original complaint, we could see that it was filed in the SDNY, but they filed against Binance, CZ, Yihei, and Roger Wang. And I think in part where these plaintiffs went wrong and where certain other ones actually chose right, for example, in the Hex versus CoinmarketCap complaint, where this Hexakin is suing CoinmarketCap for price suppression, he sued CoinmarketCap in Binance US and Binance and CZ. So he named Binance US, and I think that that would be enough of a hook to get jurisdiction over Binance US, because Binance US is the Binance subsidiary that operates within the United States. So these plaintiffs could have overcome that issue of naming the proper party and getting jurisdiction over that party by naming Binance US in addition to Binance. So that was flaw number one with the plaintiffs in this case with their complaint. It's also problematic that the plaintiffs did not adhere to the 1-year statute of limitations that this judge imposed on the plaintiffs. Had they filed earlier, at the time that they knew of the wrongful conduct of Binance, then perhaps they would have overcome that procedural bar, that being the statute of limitations that imposed that time restriction on their claims. And perhaps if they would have filed earlier, their claim wouldn't have been kicked out on this motion to dismiss. Now, that is one of the striking differences that we see between this complaint against Binance and the complaint that was noted that we actually covered a video that's linked in the description below on the lawsuit that investors filed against Coinbase, alleging that Coinbase is engaging in the sale of unregistered securities. Those plaintiffs, I believe they filed within the year. I don't know, I'd have to go back and double check that. That could be an issue if they didn't file within the 1-year time frame, considering that there's now some precedent on the books to kick it out. Although it's not binding by an appellate court, it certainly could be persuasive. But in that case, the Coinbase case, that is a domestic exchange. So they filed against Coinbase, which is domestic to the United States. So that hurdle would be overcome. So ultimately what we saw here is this case being kicked out based purely on these procedural rules, whether or not the claims actually had merit, which I believe, I mean, it's possible, but we'll never get to know because the case won't be heard on the merits because they got bounced on a procedural rule. So just, word to the wise out there, if you're seeking any sort of action, do it quick, do it fast, and name players that are within the United States, or see if you can rope in some of these players into the jurisdiction. I know that, as we noted in the class hex action, or the hex class action lawsuit, the judge actually permitted the plaintiff in that case to serve CZ, Changpeng Zhao, over Twitter because he was pretty much ducking service by operating as what the court called an international ghost. So just some food for thought. We're going to link those other related videos down in the description below. And with that said, if you like this content, please hit that like button and subscribe to our channel. We'd really appreciate that. And with that said, thanks again for watching, and we'll see you all in the next video.